Hi, I'm Jeff McDonald. I'm an attorney with Hassett & George, and I wanted to talk to you today about a recent Connecticut Supreme Court case, Marciano versus Diego Jimenez. It's a decision that just came out about a little over a week ago. December 22nd, it was just released. And what the Supreme Court did was it gave us instructions on how to interpret the collateral source statute. What they held was that if there's any right of subrogation, that there is no collateral source that will be taken away from that award. And that decision is not helpful for defendants. So in the underlying case, it was a motor vehicle accident that was tried to the court, and the jury gave the plaintiff, awarded them about $84,000 in past medicals. Of the $84,000, $2,000 or so had been paid by the plaintiff. The other $82,000 was paid by the plaintiff's health insurance company. And that health insurance company was an ERISA plan, so they had a right of reimbursement. There was a collateral source offset hearing, and the trial court did give a collateral source reduction of about $25,000 when considering the premiums paid for the ERISA plan, the amount that the ERISA was owed, and the amount that the plaintiff had paid. And the amount that the ERISA, the health insurance company, was owed was about $7,000. So of the $82,000 that it had paid, it was claiming about $7,000 that it was owed. After the trial court awarded the collateral source offset, the plaintiff appealed the case. And the Supreme Court took the case from the appellate court and decided this issue. What the plaintiff was claiming was if there's any bit of right of subrogation from the health insurance company, then there should not be a collateral source offset at all. And the Supreme Court agreed with them. And what the Supreme Court did was they held that given the language, the specific language within the collateral source statute, if there is any right of subrogation, there is no collateral source. So in this circumstance, where there's about $82,000 paid by the insurance company, but they're only claiming about $7,000 as a payback, the Supreme Court said that doesn't matter. It's whether there's any amount that ought to be paid back. And if so, if there's a right of subrogation, then there is no collateral source offset. So in that case, there was no collateral source offset. We expect to see this now not only with these ERISA plans, which have a statutory right of such an offset or such a right of subrogation, but also in Medicare and Medicaid. We've had these files, and I'm sure you all have had these files where there's $100,000 in medical bills, but only about $45,000 or whatever the number is was paid by or the lien of Medicare. In those circumstances, we've looked at the $45,000 as the actual dollar amount that will be paid back. Here, given this decision, given the Marciano decision, what the court is saying is that it doesn't matter what the payback amount is. If there's a right of subrogation, then there is no collateral source offset. So we expect the plaintiff's bar to take this and run with it. It's only been a little bit, so we don't know exactly what the ramifications will be, but we expect that this will have impacts not only on the post-hearing, post-verdict motions, but also in settlement discussions where the plaintiff's counsel is saying, hey, all of this amount is due the plaintiff, not just the amount that's owed to the insurance company. So we expect that this will have a significant impact on resolving cases. But if you have any questions about this decision or other issues with respect to collateral source, please feel free to reach out to myself or one of the other members in our insurance practice at Hassett & George. Thank you.